All right, let's dive into something really interesting today. We're tackling expectancy in contract law. Basically, what happens when a promise is broken and how do courts try to fix things. You guys sent in some fascinating excerpts from legal scholar Thomas Goldberg's book on remedies. We're looking at chapters 1 and 10 specifically, so ready to unpack all this.
Absolutely. I'm ready to jump right in. It's one of those legal areas that sounds deceptively simple at first, but gets really complex really quickly.
Totally. So we're dealing with broken contracts. And I know what you might be thinking, time for some old school punishment, right? But modern contract law isn't really about punishing the person who broke the promise. It's more about figuring out how to make the injured party whole.
Exactly. Think compensation, not revenge. And the big idea guiding that compensation is expectancy. Instead of going after the person who messed up, courts want to put the non-breaching party in the position they would have been in if the contract had gone smoothly.
Like saying, okay, you didn't keep your word, but we're going to try to make it as if you did, at least financially. But I bet actually doing that gets pretty complicated.
Oh, absolutely. It's rarely a simple hand-over-the-cash situation. Lots of factors at play. Take the famous P.V. House v. Garland coal case, for example.
Yeah, the mining company that promised to fix up a family's land after digging it up.
Yeah.
And decided, nah, not doing it.
Exactly. And it perfectly shows the tension between what it costs to fix something versus how much the value actually decreased. The company argued that restoring the land would be way more expensive than the land's drop in market value.
Which, I get it, from a purely financial angle. But then you've got the PV houses stuck with a ruined property. Seems kind of harsh to say, well, your land's technically worth a bit less now, so here's some money. Have fun with that mess.
You've hit on the problem. Economic waste. The Restatement of Contracts, which is basically a guidebook for contract law, really grapples with this. It suggests that if the cost of fully fixing a breach is insanely high compared to the actual value decrease, then maybe a smaller value-based remedy makes more sense.
Okay, I see the logic there. But Goldberg brings in Mata and Linser, other legal scholars. They point out not all contracts are just about cold, hard cash. Sometimes there's emotional value, stuff you can't put a price on. Your home's your home, right? Not just about its size or what someone would pay for it.
Exactly. That's where things get even more complicated. How do you measure something like a love of home, that personal value? It's super tricky. Huge debate about whether courts even should try putting a price tag on that kind of thing.
And Goldberg points out how businesses and individuals value things differently, too. He mentions legal scholar Muris, who argues businesses are all about the bottom line market value, profits, all that. But individuals might have deeper reasons for a contract.
Absolutely. So we can already see how this idea of putting someone back in the same position gets messy. Constant tug of war between objective value and those fuzzy subjective feelings that are hard to measure but still matter a lot to the people involved.
So we've covered how money often comes into play when contracts fall apart. But what happens when money's not really the point? When you really just want what was promised in the first place? That's where specific performance comes in, right?
Exactly. Specific performance is like a court order, making the party who messed up actually fulfill the contract terms. And it's not only for super rare or one-of-a-kind stuff. It can happen with everyday things, too.
Walk me through it. Goldberg talks about Sedmak v. Charlie Chevrolet. Couple orders a special Corvette. The dealership tries to back out. Court forces them to hand over the car. It's not like it was some priceless vintage Corvette. What made this car worthy of specific performance?
Great question. It shows how specific performance isn't just about how rare something is objectively. It's about if you can easily find a replacement. In Sedmak, the court got it, while not unique, that Corvette had specific options, the certain condition that mattered to the buyers. A replacement wouldn't cut it. They don't make them like they used to.
So they weren't just buying any Corvette. They were attached to this specific car.
You got it. This ties into the Uniform Commercial Code, or UCC, governing goods contracts. Legal terms aside, it's basically rules a lot of states use to keep buying and selling consistent.
So the UCC is like the rule book for buying and selling stuff.
Exactly. And Section 2716 of that talks about other proper circumstances where specific performance fits beyond just uniqueness, where money doesn't truly fix the harm.
Interesting. Makes me think of another car case. Goldberg mentions Bander v. Grossman, or a rare Aston Martin. But that case, no specific performance. If a special Corvette qualifies, why not a rare Aston Martin?
Excellent point. Gets to how courts decide if money truly covers the loss. In Bander, while the Aston Martin was rare, they found a comparable one could be bought. even if it took time and effort. So even if something's rare, the question is, can you find a decent replacement on the market without a huge struggle?
Not just about being rare or unusual, it's got to be practically irreplaceable for specific performance to be on the table. Fascinating.
Exactly. Courts are always weighing, is it more reasonable to force the seller to hand over the thing or just give money to cover the loss?
It makes sense they wouldn't want to force a seller into something crazy disruptive if there's a decent alternative. Okay, so we've got situations where the fix is clear money or the exact thing promised. But what about when it's hard to put a dollar amount on the harm, like lost profits, especially for new businesses? Goldberg uses the Drew's case, where a drive-in restaurant got messed over by a contractor.
You're right, lost profits are tricky, and Drew's is a classic new business rule case. Traditionally, courts hesitate to award future profits to brand new businesses. It's too uncertain. An established business with years of records, you can kind of see what they were earning. But brand new, it's way harder to prove what they would have made if the contract went well.
Like you're trying to predict the future. Too many what-ifs.
Exactly. But like a lot of law, this rule's gotten less strict. Now it's less of an absolute no, more of a prove-it situation.
So it's possible for a new business to get lost profits. Just really hard to prove.
Exactly. And Goldberg uses how the South Carolina Supreme Court's thinking has changed as an example. It's now about reasonable certainty. Can the injured party give strong enough proof, market analysis, projections, how similar businesses did to make their lost profits claim believable?
Can't just say, well, it's going to make $1 million. Got to back it up.
Right. Solid evidence is key. And this is where a good lawyer comes in. They'll help you get that evidence, present your case convincingly to the court.
Solid advice. So entrepreneurs listening facing a breach, don't assume you can't get anything for lost profits. It's tough, but doable.
For sure. And this brings up something else. What about emotional distress? Suing for that when a contract goes wrong.
Ooh, good one. See in movies all the time, someone's devastated, sues for millions.
Right. But real life's not always so simple. You can't just sue for emotional distress whenever someone wrongs you. It's a common misunderstanding.
So what's the deal with emotional distress in contract law? Is it ever a thing?
Well, it depends. The usual rule is it's not really compensable in business contracts, especially if you can calculate the financial loss. Courts see contracts as mainly about the money, not feelings. But there's always a but. In law, there are exceptions.
I was hoping you'd say that. When might it be a factor then?
Yeah.
Goldberg uses actress Shirley MacLaine as an example. She was offered a different role after her original film got scrapped. Not happy about it.
Yeah. Her case, officially Parker v. 20th Century Fox, is fascinating because it gets into those exceptions. Even though the studio offered her the same pay for the new role, she said it was inferior, would hurt her career.
So, more than just the money for her, it was about reputation, her future as an actress.
Exactly. And the court agreed. They realized that in some careers, acting being a big one, a worse role could really mess with your future earnings beyond just that one paycheck.
So, not just being upset you didn't get your way. Got to show real harm to your career, your rep, something beyond just hurt feelings.
Precisely.
Yeah.
High bar to clear. Courts are very careful about awarding for emotional distress in contract cases, and for good reason.
Yeah, I could see how it could get really subjective and hard to measure. But it's cool that the law gets that sometimes a broken promise has effects way beyond just the financial.
Absolutely. Shows how complex this all is. But in the end, contract law wants a fair solution, putting people back where they'd be if the contract worked out.
Which, we've seen, is way easier said than done. So many details matter. Really makes you realize contracts are more than just pieces of paper. They're real promises, real expectations, and when those get broken, ripples everywhere. So we've really gone deep on expectancy, looked at big cases, and unpacked some pretty heavy legal stuff. But before we wrap up, back to our listeners. What are the key things to remember here, even if you're not a lawyer, but you want to be smart about contracts?
Such a good question, because knowledge is power, right? The more you get about contract law, how it all plays out, the better you can protect yourself. Big takeaways, think about remedies before things go wrong.
Okay, so like an ounce of prevention, even in the legal world.
Exactly. One way to do that is pay attention to the contract itself. Don't just skim and sign, really get what you're agreeing to. What happens if someone breaks their promise?
Channel your inner lawyer, even if you don't wanna. Any specific parts of a contract really zero in on.
Absolutely. One example is liquidated damages clauses. They basically say up front what the penalty is if the contract's broken.
So instead of the court deciding what's fair after the fact, you try to set it beforehand.
Right. Now, like we saw in that Lake River case, It's got to be reasonable, not about punishing anyone, but done right, it makes things much more predictable for everyone.
Makes sense. Avoid those court battles if you can. What else helps protect yourself?
Be crystal clear about what you expect. Some fights happen just because people had different ideas of what the contract meant. Define those key terms, think about what could go wrong, and don't be shy about asking questions, even negotiating. Better to hash it out early than when things are a mess.
So be proactive, be informed, and when in doubt, call a real lawyer.
Couldn't have said it better.
One last thing's been on my mind as we've been talking. We've said courts want a fair outcome, often focusing on what's economically, financially, reasonable. But we also saw how much those personal feelings matter, like the PV houses and their land. Do you think courts should care more about that subjective value, especially for everyday people, not big companies?
Wow, such a great question. And honestly, no easy answer. It's something legal experts and judges are still figuring out. On the one hand, you want the law to be predictable, consistent. If we rely too much on feelings, it's hard to figure out damages, could even be unfair or random.
Right, like my priceless heirloom is someone else's dusty old thing.
Exactly. But then again, if it's about truly making the injured party whole, totally ignoring those personal non-money harms just feels kind of wrong sometimes.
Like you can't put a price on everything.
Exactly. And that's the tough part we've been wrestling with this whole time. Finding that balance between objective fairness and recognizing those less concrete harms it's not simple.
For sure not. And I think that's a perfect note to end on. Something for us all to ponder. Contracts aren't just about money, they're about promises, about what we expect from each other. So as you're out there dealing with contracts, remember, be informed, be proactive, ask those questions, and hey, if you're ever unsure, a legal pro can help you make sense of it. Thanks for joining us for this deep dive, everyone.